Right. Yes. Are we hearing from you, Ms. Hill?
My Lords and my Ladies, just very briefly to indicate that over the lunch adjournment we've made arrangements for two authorities that I alluded to be provided to the court. Very briefly, one is the case of A, in which one paragraph, paragraph 27, is highlighted with a proposition around dual characteristic discrimination.
Yes.
The other is the case of Markin. Again, one paragraph is highlighted, page 1, paragraph 127, that deals with the issue of the weighty reasons for gender discrimination. So they are en route to you now, and I apologise that they weren't in your bundles before.
That's fine. And for what it's worth, I do now have the Joint Council for the Welfare of Immigrants case. I have in fact read it before, but I've now got it.
My Lord, would it help just to remind you then that the two paragraphs in that judgment that I went to in particular were 136 and 139.
Thank you very much.
Thank you, my Lord. With that, I will now hand over to Mr. Straw. Thank you very much.
My Lords, my Lady, I'm dealing with indirect sex discrimination under EU law. This is dealt with in the judgment below at paragraphs 56 onwards, and in our skeleton argument at paragraphs 18 to 43. The Divisional Court dismissed our claim that the legislation at issue was unlawful indirect discrimination contrary to Article 4 of the Social Security Directive. And it did so on the basis that Article 7 of that directive exempted any discrimination of which we complain from the scope of the directive. In my respectful submission, the Divisional Court was wrong to hold that any discrimination was exempted. The Divisional Court, because of its finding on Article 7, it didn't go on to consider whether there was indirect discrimination under EU law or whether it was justified. In my submission, the approach the Divisional Court took to Article 14 discrimination was materially different from that which is to be taken under EU law. And as a consequence, its, we say, erroneous decision about Article 7 was a material error, which would at the very least justify this court remitting the matter to the Divisional Court. If I may, I would hope to deal with my submissions in the following way. Firstly, to look at Article 7, and then to move on to look very briefly at indirect discrimination and justification under EU law to try and make good my point that this was a material error.
Well, I think the view that we've taken at the moment, Mr. Straw, is that we've lost a bit of time this morning with the time estimate of 3 hours. And so I think what we'd like to hear you on Article 7, and in due course we'll hear Sir James on that. And we may, depending upon whether or not we can come to a firm conclusion about whether or not the Divisional Court was correct about Article 7, we may then at an appropriate time call on you to make your further submissions on indirect discrimination under EU law.
Thank you. May I just check that Lord Justice Underhill, the Vice President, can hear? The screen is frozen.
Yes, out of curiosity, why did you think I might not be able to?
The screen, at least to me, appears to have frozen.
Oh, right. Well, there we are. Anyway, I can hear you.
Okay, thank you. Very well, I'll only deal with Article 7 then, and I should hopefully be very brief. A summary of my submission on Article 7 is as follows. Article 7 commits discrimination in the determination of pensionable age for the purpose of awarding a pension. Whatever the literal meaning of those words, they must be interpreted strictly and in accordance with the purposes of the directive and of Article 7 itself. And those purposes are, firstly, to recognise the reality, to enable member states to temporarily retain pre-existing differences in state pension age and discrimination that's necessarily linked to those differences, while at the same time progressively implementing the principle of equal treatment, which means progressively eliminating indirect and direct sex discrimination. And in my submission, the indirect discrimination of which we can complain here, which is indirect discrimination caused by an equal state pension age, in my submission that falls outside those purposes, because firstly, it's not a pre-existing difference in pensionable age or discrimination that's necessarily linked to it, and it is contrary to the principle of the progressive implementation, the progressive elimination of direct and indirect discrimination, because it creates new indirect discrimination, which wasn't there before. And to make good those submissions, I'd like to look first, please, if I may, at the directive itself. This is in your first authorities bundle, tab 4. And if you could turn that up, please. So tab 4 should be the Social Security Directive. And in both the title and Article 1, it makes clear that the purpose of the directive is the progressive implementation of the principle of equal treatment. And then over the page as Article 4, it explains that the principle of equal treatment means that there shall be no discrimination whatsoever on ground of sex, either directly or indirectly. And it goes on to give some more detail about that. The exception is in Article 7 at the bottom of the page there. This directive shall be without prejudice to the right of member states to exclude from its scope A, the determination of pensionable age for the purposes of granting old age and retirement pensions, and the possible consequences thereof for other benefits. And it's A about which we're concerned here. Could we then turn, please, to the case of Richards to see how that provision has been interpreted? And Richards is in tab 9 of the same bundle. Richards was a case on different facts to today's case. The applicant had had gender reassignment surgery from male to female, and at age 60 had claimed state pension. And at the time, the state pension age for women was 60, while that for men was 65. And that claim was refused, and Ms. Richard made an application to challenge that, arguing that it was discriminatory. Could you turn, please, to paragraph 25 of that case? And at paragraph 25, it's noted that the UK government submitted that the discrimination issue fell within the exemption in Article 7, and so it was not unlawful. And the court goes on then to consider the arguments about that, and over the page at paragraph 34, says this. Furthermore, discrimination contrary to Article 4 of Directive 7, which is the Social Security Directive, falls within the scope of the derogation provided by Article 7 of that directive only if it is necessary in order to achieve the objectives which the directive is intended to pursue, by allowing member states to retain different pensionable age for men and for women. And we rely on that passage as showing that the exemption in Article 7 should be interpreted purposively. It permits discrimination only if that discrimination is necessary to achieve the objectives of that directive. it explains in paragraph 35 in a little more detail what those objectives are. And they are, in summary, as the Divisional Court put it, to recognise the reality, to recognise the fact that member states have pre-existing inequalities in state pension age, and to allow them to temporarily maintain those inequalities and discrimination that's linked to them, while at the same time requiring the overriding purpose of the directive to be put into effect, in other words, the progressive elimination of indirect and direct discrimination. And so we rely on that case as showing that Article 7 must be interpreted as only allowing discrimination which falls within those purposes. Paragraph 36 emphasises that according to settled case law, the exemption to the prohibition on discrimination on grounds of sex provided for by Article 7 must be interpreted strictly. In paragraph 37, consequently, that provision must be interpreted as relating only to the determination of different pensionable ages for men and for women. However, the action in the main proceedings does not concern such a measure. Now, in paragraphs 34 and 37, the European Court of Justice there notes that the exemption only permits discrimination in different pensionable ages. And of course, that's not what we're concerned with in this case. The Divisional Court considered that the reference to different was merely a reference to the facts of the particular case. And so it can't be limited to the facts of the case. Perhaps more importantly, it's consistent with the objectives, which are to permit pre-existing discrimination, but not to allow member states to bring about new discrimination which isn't necessary for those pre-existing states of offence. The Divisional Court essentially gave three reasons for rejecting our case and holding that Article 7 applied here. The first was that the language of Article 7 doesn't include the words unequal or different. It doesn't say that the exemption permits discrimination in the determination of different or unequal pensionable age. But in my submission, this shouldn't be interpreted literally. It must be interpreted purposively, and we refer again to paragraph 34 of Richards. If it was interpreted literally, that would lead to absurd results. For example, it would appear to permit member states which started from having equal state pension ages and entirely non-discriminatory pension systems to decide to have unequal state pension ages and bring about discrimination which was linked to that, and clearly that cannot be right. The second reason given by the Divisional Court was that our submission doesn't make sense, and it mentioned that it could lead to bizarre results. And our response to that is, once one understands what the purposes, the objectives behind the directive and the exemption are, then it does make sense. It makes perfect sense to permit pre-existing discrimination, but not allow states to bring about entirely new and unconnected discrimination. And the final reason from the Divisional Court was that our interpretation would amount to a disincentive or a bar to member states equalising state pension age. And our response to that is we respectfully disagree. Firstly, if the UK were to bring in a way of removing the disadvantage which women face as a result of equalising state pension age, then there wouldn't be indirect discrimination, or there would be less indirect discrimination. So, for example, if the UK brought into effect a pension credit or a benefit for those on low means who lost out as a result of the changes, then that may remove or at least reduce the particular disadvantage, and therefore make indirect discrimination less or non-existent, which would mean that state pension ages could be equalised. Further, our case at one level is seeking a declaration of incompatibility. So we say, and this is set out in more detail in our skeleton argument, but one of the problems here is that Parliament hadn't recognised the indirect discrimination or decided whether or not it was justified. And so at one level, we are asking for the courts to draw attention to the indirect discrimination, but then that would leave it to the government and Parliament to decide whether to do anything about it.
Sorry, well, when you say a Declaration of Incompatibility, you don't mean in the 1998 Act sense.
No, sorry, you're quite right. Under the EU law case, we are seeking a declaration. I should have said declaration rather than Declaration of Incompatibility. But it's a similar aim in that at one level, we're asking for the indirect discrimination to be drawn attention to. Now, if the case were to come back and government and Parliament had clearly recognised that there was indirect discrimination, but decided either it could only do a little bit about it, or
well, that may be what you're asking for. But is there any case law on whether these provisions have direct effect?
The Social Security.
You'd be asking for that, but if we make that declaration, does that then suggest that there is a directly effective right on the part of women relying on the directive to make a claim for arrears of pension payment?
I see. I think probably the most helpful case on the effect of this is the Equal Opportunities case in the House of Lords in 1995, which is in the bundle. It's tab 24, which I think will be in your second folder. And this was a case where the Equal Opportunities Commission was complaining about unfair dismissal protections being removed for part-time workers. There was a claim that that was indirectly discriminatory treated EU law because more part-time workers were women than men. And the House of Lords granted a declaration that the law was contrary to EU law. And from recollection, I don't think there was the consequence that this would mean, the consequence that my Lady Justice Rose has drawn attention to. I don't think that House of Lords indicated that that would follow.
But the situation's not analogous, is it? Because unfair dismissal claims would be brought against private employees, so that it couldn't be, private employers, it couldn't be directly effective. But I think in any event, but in this case, the pension is paid by the government.
Yes, I see your point. It is different in that effect.
Now, I'm quite interested to know what the content of the declaration would be. It wouldn't help anyone much to say that it was that the equalisation procedures were indirectly discriminatory, or contrary to the directive. You'd have to say in what precise respects they were discriminatory, which would enable Parliament, as it would have to be Parliament, to put them right. So what are you saying EU law requires?
I think our primary case is the declaration would be that there's indirect discrimination which isn't justified. But
that by itself wouldn't help anybody. You'd have to say, clearly you wouldn't have to write the legislation again, but you would have to show in what respects it wasn't justified, which would necessarily mean how a justified measure could be devised. What's the respect in which it's unjustified?
we say it's unjustified. Our submissions on justification really rests on.
We've stopped you making them, but I think you can tell us the nature of them.
Yes, but in summary, leaving aside the margin of discretion point, we say the three key justifications that have been put forward are insufficient. So the first justification is that the first aim or objective of the directive. Sorry, I'll start again. The first aim.
It's my fault. I didn't answer. I didn't direct you quite directly. It was not to say what's the nature of your challenge to the justification of reasoning. I would just like to know what you say a lawful outcome would be. You could say that, and this may be what you do say, that actually, given the economic disadvantage which this cohort of women suffer, it was unlawful to seek to equalise their pensions full stop, and they should stay at 60. And if that were the outcome, then it would follow, as my lady says, they'd have claims for arrears of pension. But your position might be somewhere in between. I just don't quite know what the outcome of this case that you're seeking is, even if you can't get it all from this court first time round.
To try to answer that question, I hope it helps just to very briefly outline why we would have said that this is indirect discrimination and why it's just...
I'm not sure I really want to go into that at this point. I would prefer you to restrict yourself to Article 7 and why it doesn't apply at this stage, if you don't mind.
Of course. Trying to, I suppose another way of asking, my Lord, the Vice President, answering the Vice President's question, maybe to point to the declaration which was granted in Cole, completely different set of facts, but that was the Supreme Court case about probation hostels, where the declaration was that there was discrimination which hasn't yet been justified.
I see.
And that may be a declaration that's appropriate in this case as well.
Well, I'm sure my Lord is right. I've asked questions which perhaps go too far away from the Article 7 point. We can explore it further when and if we get to it. Thank you.
Thank you. Those are all the submissions I hope to make about Article 7, unless there's anything else you'd like to ask me about it.
No, I don't think that I have any questions. No, it doesn't look as though anybody else has any questions. Thank you
Well,
very
I've
much.
got one more question, which may venture into the forbidden territory, but I think not. I think I need to know the answer to it. Do I understand that the nature of the indirect discrimination of which you complain is essentially the same as that relied on in the convention ground? That is to say that the effect of bringing women up to the same pension age as men is indirectly discriminatory because they are socio-economically less well placed to take the hit, so to speak.
Yes, and also under the 2011 Act, bringing both men and women up from 65 to 66 has the same disadvantage because women are in a worse socio-economic position, or at least women born in the 1950s.
Okay, but that's important, I appreciate, but that should be a curly Q on the main point.
Yes.
Yeah, okay, thank you. Thank you, that was what I wanted just to confirm.
Thank you.
Right. Thank you very much. Any other submissions?
No, thank you. I'll hand back to Mr. Mansfield, if I may.
Thank you very much indeed, Mr. Straw. Yes. Mr. Mansfield. Is Mr. Mansfield there? Right, we can't see you at the moment.
Did my my experience, if you say a few more words, you may become visible.
Yeah, my camera's on according to this anyway. I'm saying a few more words. I don't know whether that
Yes,
means
there we are. Yep, you are. Yes. You can see you now.
Much obliged. Can I then turn to grounds 3 and 4? Put shortly, notice and delay, and obviously deal with notice first. May I make a preliminary observation in the hope of clarifying and, as it were, disposing of two concepts which have been conflated. There are very good reasons why they might have been, but the first point I would want to make is that our claim relates to notice, not to consultation. We say that for two reasons. One is that the most common complaint made by the women in this cohort, besides lots of others, but one of them is, and it's contained in the one I read to you this morning of the second claimant, who's first in time, that she didn't actually receive any notice at all, and she was completely unaware until the year before. Putting it compendiously, there are a large number of women who either say they never had a letter or they weren't aware until 1, 2, 3 years before they were due to receive their pension. So it's a very common grievance, whether one likes it or not. That is, in fact, the situation on the ground. The second point here is that the conflation has arisen because I hope I have this summarized correctly. There is no case law that relates to notice on its own. Now, there may be very good reasons for that. For example, the authorities which are cited in the skeleton and in the ground, all of them, Hammersmith, Doody, Bappione, Niazzi, all link the two together. That is, notice, but they don't all mention notice. They're all dealing with essentially consultation. Now, the reason we have not suggested, or desirable as the words of one judge has said, though it may be, I think it was Lord Justice said it, that there should be consultation. That's not what the women are saying. They're saying, actually, although we might have liked to be consulted, what we really needed was notice. So that on that basis, there is a concern, because the cases link the two, to uncouple notice and consultation. Because putting it in the vernacular, you can have notice without consultation, but very difficult to have consultation without notice. And there are obvious reasons here. And the reasons why we are not claiming consultation are spelt out in great detail in the authorities, because, of course, you're right on the borders of the separation of powers between the executive and the judiciary and so forth, because it could be interpreted that at the point or the boundary of consultation, you're entering into the legislative arena, or you could be. But that's not what any of the women are really saying on this. They're just saying, we did not know. And so, may I say how important this distinction is? One, because as far as I know, there's no direct authority on it, and I've tried to distill a principle that could provide your lordships with a way forward on this, should you be sympathetic to the point. If you would be kind enough to look at the judgment, again, for these purposes, which comes in the core bundle at tab number 8. Core bundle, tab 8, and this is the judgment as a whole. I'm going to go straight to the portion of it that illustrates this initial point. If you're on page 95, please, and you go to paragraph 118, where these are the conclusions of the lower court. And essentially, for the reasons given, I'm just reading the first paragraph as an example. There'll be other paragraphs in this that are important, but this one, essentially, for the reasons given by the defendant, we are clear that the claimant's case on notification must fail. If and insofar as the argument based on legitimate expectation is founded on any implied undertaking or promise to those in the claimant's position, that promise could only amount to: Parliament won't alter state pension age unless there has been prior consultation with the individuals affected. Well, that's not what we're saying. That's what other cases may have tried to argue. No such promise or representation was ever made. In addition, it is clear that successive governments engage in extensive consultation. So it's there as an example in which the two have become conflated. And we say it's important that they should be kept distinct if the claim we are making has some merit. So consultation confused in that way. But may I just pass, therefore, from that aspect of it, just to deal with a fact that relates, or facts that relate to this. The reason why, and I'm only going to do it very quickly on the factual basis, because my learned friend, Sir James Eadie, takes issue with the fact that the facts were in challenge at the lower court. It's not just that individual women were saying that they hadn't had letters of information. It was, in fact, much broader than that. I can give you the reference so you can look it up, you may remember. There was a survey done by the DWP in 2012, which indicated, you will find it, it's in the judgment if you still have it. It's quite an important paragraph. It's page 89, paragraph 82. Page 89, paragraph 82 sets out one of the factual areas, which in fact comes from the DWP itself. Now you will have noticed that 2012, of course, is within the period in which the schemes are already taking effect. But even then, even in 2012, you will see in that paragraph, there's no issue that this was how it was reported. And it comes, as I say, from the witness, Ms. Fox, Wendy Fox, who was in charge of digital information. She says, focusing first on women, it can be seen that among women overall, 1 in 10, 11% in 2012, correctly identified their SPA state pension age. For the remainder, forecasts were skewed towards those who were overly optimistic in terms of the age at which they thought they would be eligible. Over 6 in 10, 62% women who had not reached SPA believed that they would receive their state pension before their real age entitlement, while 2 in 10, 21% believed that they would receive this after their real age entitlement. So this was one of the bases for saying that basically it's not every woman in this category, but a large number of them, even once the scheme was taking effect, still didn't know what their pension age should be. The third matter, and this is the last factual one just for the moment, as to why this may have come about, is because direct mailing, it's sometimes called individualized or personalized mailing, with the details of an individual's state pension age, because your lordships will and ladyship will be aware from the tables that they're not all exactly the same. Were not sent out, and again, I'm not going to ask you to trouble to turn the tab up, but you will also find this at paragraph 124, paragraph 26, 46, tab 2.
Hang on. Sorry, you're making a number of references there.
Wendy Fox.
Sorry, sorry. What is the reference you want us to note?
Of the supplementary bundle.
Supplementary bundle, yeah. Which
That is the statement of Wendy Fox,
yes.
and at paragraph 46, you'll see in the middle of the page 124, that's the mailing. And what happened was, and that sets it out, but I can summarize it. You can see 2/3 of the way down the paragraph. What happened about direct mailing was that it started properly in April 2009, and the first period lasted until March 2011. So it started just before the operational start date of the scheme in 2010, continued into 2011, but of course then there was another statute going through, so there was a gap while that statute was passed, and then there was a second period of direct mailing with a larger number specified in that paragraph, from January 2012 to November 2013. Now, on the basis that it is accepted that the DWP were saying themselves that the minimum period that should be given was that of 10 years, you'll find that in the judgment at paragraph 83. That was from the pension in 2007. It indicated that 10 years.
Where's that?
Was the It's in the judgment at paragraph 83.
I'm just looking at paragraph 83. I don't see it. I'm sure it's there, but just show me where.
I'm so sorry. I'll just check I've got the right.
The second bullet on page 90.
90. It's 89 and 90. Yes.
And it's the second. It's the second bullet is at the top of the page.
Yes.
Okay. Thank
Yes. I'm sorry. It's over the page.
Hang on 1 second. Let me just see what that is. Well, that's from July 2017, isn't it?
Okay. Page 90, right at the top, as you said.
Yes, but that's from July 2017.
Yes. So what I appreciate. In fact, they've been saying that earlier. I can go through the earlier one. Not necessarily specifying 10 years.
Oh, well, sorry, that's the point. You say, speaking for myself, I don't need to be reminded of it because it's in the judgment, that from before, right up to the debates before the 1995 Act was passed, there was a reference to the need to give notice of all the changes in some form.
Yes.
But I didn't see any reference to 10 years at that time.
The 10 years I'm not indicating that 10 years had been discussed all the way through the previous years, but what had been recognised in the passage of time up to 2017 was that, and of course this was a recognition, slow recognition, we say this is the problem, that actually the message was not being conveyed, was not reaching its destination, even by the time of the scheme. So something as late as 2017 is indicating it's really got to, even in then, to have at least 10 years. What I'm really saying is,
I think
it's clear for many years before this, that in fact the message wasn't getting through. And it was very variable, not always calculated in terms of 10 years. But certainly there was an understanding, an acknowledgement that it wasn't being successful. And that's another reason why, and if it's as bad as that in 2017, then we would argue that there is clearly a shortfall, and we get that in the individual.
But is this really talking about notice in the sense that you're talking about notice now, which is notification, or is what they're saying you need to have, when you legislate, you need to make sure that there is a 10-year period before anybody is actually affected by an increase in their pension age. It's that kind of, it's more a sort of lead-in rather than a notice, but you're talking about something different. There's no doubt that these women, the applicants, the claimants, did have a lead-in period, in that it wasn't that their pension age was the next year reduced from, or raised from 60 to 66. There was a period before they became 60, a 10-year period before they became 60.
Yeah.
Isn't that what it's talking about, rather than a need for individual
Yes, I quite agree. It's not saying they must be sent individual notices 10 years before, but the actual process of notification generally. But that encompasses and embraces, and what we say is that having a public debate, if that's what it's about, notification on that basis is not enough in relation to something of such gravity as this, that is going to affect life decisions for a large number of people, and knowing precisely when your date is going to come about, because of course the original statute in 95 was changed again in the middle of the process of sending the letters out. All right, only by a year, but it matters. And we say in that context, notification generally should, we say at the end of the day in a case like this, involve notice to the individual pensioner once the scheme has settled as to what the final date is going to be. So, in fact, we do say a notification generally is important, but, and obviously that is one of the aspects of this, that the public should be alerted well in advance. But we say we go further than that. The individual actually directly affected by these provisions should be given, and it's arbitrary to say it should be 1 year, 2 years, 3 years, should be given individual notice in sufficient time for that person to make the changes that they have to do, which can't be done certainly can't be done within a year or 2 or 3. If I say 4,
those changes are they, Mr. Mansfield? Mr. Mansfield, it entirely depends what those changes are. Some will have to make big changes, some won't have to make any. Some will make changes that can be made. For example, take a simple case. Suppose your employer is very happy to keep you working, but typically, as employers tended to do in the old days, simply let you go at state pension age. You don't need much notice. You just need enough time to tell your employer, actually, I don't want to go at 60 because I won't be pensionable. I'd rather go at 65. The employer says, fine. That doesn't require any planning at all. Now, of course, it's not as simple as that. There are many cases where they may have to make more elaborate arrangements. The point I'm making to you is that it will be extremely variable. You can't assume everybody needs to know 10 years in advance because they have to make incredibly sophisticated plans, or even 5 years or 3 years. It'll depend.
Well, the case that I read, obviously, is the applicant herself. You see from that.
But it's not what she could have done different.
But there's a lot that if she'd known in advance that was the situation, first of all, you wouldn't leave the job you've got, probably. That's one thing. You make provision, if you're not going to get the full state pension, or you're not going to get it for 6 years, that's a lot of money, as I indicated in the opening. So you have to make alternative provision for yourself. At an earlier age, you're having to do it. And so you can't definitely say to yourself, I've now got to raise enough money, because I don't get the pension. I've got to raise enough money. And this is the average case, not the unaverage case. The average case is the woman having been on low wages, having possibly not getting the full pension at that stage, and having to care, then have to go back into part-time work, which doesn't pay as much, in circumstances which even these days is extremely difficult. Now to avoid that, what I call catastrophe, you have to be given some notice. Now, it would be invidious of me to say it has to be necessarily 10 years, although that they're written in together, but it's certainly not as simple as, oh, well, tomorrow I can tell the employer either I don't want to leave or I do or whatever. But there are, particularly where there are elderly relatives or there's ill health, what then happens? as
Am
there
I
is
right
in
in
case of
thinking,
these
Mr. Mansfield,
the
please tell
second
me if I'm
applicant.
not, that the paradigm case of someone who's in a job is that obviously things can go wrong, the company can go bust or whatever it might be, but basically people who are in a job can stay in it to retirement age, and the practice of employers has tended to be to adjust what is in practice, if not in law, compulsory retirement age to reflect state pension age. Isn't that the paradigm case? If state pension age goes up, if you're already in a job, you could probably go on in that job.
Well, I think, if I may say so, there isn't a paradigm case in that sense, because a number of women will have, one or two examples I can recall from the statements we had, actually cashed in pensions much earlier, which they say they wouldn't have done if they'd known they weren't going to get their state pension. That's a common situation that arises. So it's, even if you work to the full with your employer, if you're lucky enough to have a full-time job, if in fact the employer and you are banking on the fact you're going to get a pension at 60, some employers would probably have been aware, but then it makes life very difficult. And there isn't a paradigm case in which it's easily transferred. And this is not a situation in which even the DWP says that in fact this is going to be, relatively easy. You don't need much warning. Nobody's ever argued that. Everybody has argued that notification in the general sense is required, political debate is required, and at the end of the day, because of the complexity, it's going to be my final point in this area. Again, you can get it from the judgment. If you need to look it up, it comes from Wendy Fox. It's a comment to the effect that this is a highly complex area. That's the wording that has been used. In fact, I think by Wendy Fox in reporting back to ministers in the year 2000. It's highly complex and it is a confusing subject. So it's never going to be easy to understand exactly what the tables alone run to, I think, 8 pages. And obviously when you look at them, you can read off where you might fall. But if you haven't got the tables that in the bundle in front of you, and you are not being individually notified, you're suddenly brought up short by the fact. And the impact of losing the state pension for women who've been on lower salaries and part-time work as well is much greater. It's the point that's been made in terms of discrimination. So that is why we say that individual notice, which we say was given too late in the end, and it didn't cover all women anyway.
Mr. Mansfield, can I ask?
A fundamental requirement where you're changing, if you like, a scheme that people have depended on. And may I just turn, as it were, to a stage in the argument?
Well, can I ask a question, Mr. Mansfield, before you move on? I've been trying to raise this, but haven't had the opportunity. I think it is right to say, I think I read in the appellant's skeleton argument, that they say that as a result, it is part of the appellant's case, that as a result of the failure to give adequate notice, the claimants have suffered detriment. I wanted to ask you whether there is any passage in the evidence of either the claimant which explains what that detriment is that could have been avoided. Is there anything, do they address the question of detriment, as opposed to simply, of course, totally understandable, surprise, shock and disappointment at having a later state pension age? Because I don't remember seeing anything offhand in their statements to that effect.
No, the statements are not in the bundle, so I can't direct your attention to them at the moment, and I'm trying to recall whether either or both of the particular claimants do indicate that. We had other statements that were read where the clear detriment was, for example, where a woman with health and other difficulties was not able to even get part-time work. So the detriment was a loss of the actual pension itself. And therefore, the word that's been used commonly is that they have been driven into a class of poverty by this. That's the detriment.
Now, I understand that, but I thought that the argument was that had they been given adequate notice, which they were not, then
Yes.
they would not have suffered the detriment which they did. That's nothing to do with the inevitability of the legislative scheme. That's just to do with notice. And that's really what I'm asking about, whether or not the failure to give notice in itself caused a detriment which has been identified and which could have been otherwise avoided.
Yes, I understand your point, and I don't recall myself from the two claimant statements whether that point, in other words, if they'd known in advance, what would they have done to avoid it? I know in some statements they were saying, well, I wouldn't have cashed in, for example, that's the common one. I wouldn't have cashed in the occupational pension. I would have kept that. And I would have, some of them were talking about housing problems that they've got that they would have avoided if they'd known in advance that they were going to have to rely on property to get them through this period, or if they were going to have to rely on cash. In other words, it's all to do with preparations for saving, property, relationships, and so forth. And obviously, the one that gets missed out is mental well-being. That's a serious detriment that could have been avoided if they're not put it through this extraordinarily stressful situation.
Yes, thank you.
But I can't point to those statements, but if I may overnight, I'll see if we can locate the original statements that have been taken in order to answer that particular question.
Thank you.
May I then move to the indication that I want to develop is not only has it to be noticed, we say, individualized, there has been, I think, I don't know whether it's a misunderstanding or a misconception, but certainly we say an error in the judgment on the next stage, because we say if there is a duty to notify, I use it if you like in the more specific sense, to give notice, then in what circumstances does that arise? Sorry, could I have 1 minute because we have a reference here. DB 376. Yes, I won't interrupt the flow now, thank you very much. You can leave it there. My wife, sorry, bringing me the reference. Somebody's giving me a reference of where your Lordship's question can be answered.
Oh,
And
thank you.
I will do that during the course of the afternoon. The stage I wanted to move to is that found at the judgment, page 99, tab 8.
This is the judgment.
Of the recital of cases which deal with the really the unequivocal assurance or promise or express promise and so on. And 122 is a core part of this judgment, because it says this: in our judgment in the instant case, there is no question of a clear and unambiguous undertaking that the individuals affected by these successive acts upon will be given individual notice of the changes of the state pension age affecting them. My lords, can I deal with that? Because we never argued, and we don't now, that there is any question of a clear and unambiguous undertaking. What we do is we say, if you look at the authorities, particularly two I want to come to in a moment, the proposition is this, that in the absence of an express undertaking or an express promise or even implied promise through practice, even in the absence of that, a duty may arise, and it may arise in a number of ways. It's a fusion of substantive expectation legitimate expectation arising out of a substantive situation, and that links to Lord Justice Law's second, as it were, classification of procedural expectation on the back of a substantive gives rise to a secondary procedural legitimate expectation, and that links and runs alongside the common law, we say, duty of fairness. And we're saying all of that is in the absence. So we're not dealing with it's obvious to anyone that none of the legislation says, well, leave out consultation, none of the statutes say explicitly there will be notice. None of them do say that. And there's no practice that I can rely on to show the sort of implied part of this. So it has to be considering what happens if that doesn't exist. Now, we say that's important because...
Is this fair, Mansfield, that you are... Mr. Mansfield, is it fair that you are, in fact, it's a positive, unhelpful gloss on the way you're putting the case to use phrases like legitimate expectation or clear and unambiguous undertaking, which are all part of a particular kind of case law, directed at a different situation? You're putting your case much more broadly, as I understand it.
Well,
if you really want to put it as a legitimate expectation, you'll find yourself dragged into all these requirements which you clearly can't satisfy.
Well, except that if one adopts the reasoning of Lord Justice Laws, and you turn momentarily, because I don't have to develop it for the purposes of this case, of the secondary classification that he's got. In other words, he calls it the paradigm case, not the paradigm case, which is in that core judgment I just read. That's the paradigm. We're saying this is not the paradigm. And no one can say that there is any suggestion of an express promise. So it's not the paradigm. And the reason why we're able to say that is if you turn to page 97 of the judgment, divider 8. I'm not going through the earlier cases because they're in the bundles, but Hammersmith and the others all deal with consultation linked to occasionally notification. But this is a citation, a long one, in the judgment from Bapio, but there's a paragraph that isn't there. So if you could kindly keep that page open, because it qualifies what I'm talking about. And what is now required is to look at Bapio itself, which is in volume 2, tab 28. Volume 2, tab 28. And if you have the section of this case that, and the judgment of Lord Justice Sedley in this particular instance, although he's also in the later case of Niazzi accompanying Lord Justice Laws. But if you turn to the paragraph that precede the ones in the judgment of the court below, they are, well, the actual page number is 762. The paragraph number is paragraph 41 at the top of that page. So, of course, consultation does come into this, but I'm really wanting to distill what Lord Justice Sedley was trying to do, and to avoid all the complications of consultation and so forth. So, the obligation of fairness, so we're dealing here with the convergence of the common law duty. The question which remains is therefore whether in the absence of either an implicit bar on consultation, may I pause there He's put it that way because he does not accept the government argument that effectively, well, if the government had wanted it, then they've stuck it in the various statutes. And he says just because it isn't in a statute doesn't mean that it can't happen. So that's a bar on consultation. Or of an established practice of consultation, fairness calls for consultation with BAPEO or with those it represents on the rule changes. So that's a very important paragraph. So what comes from 43 onwards is a discussion at some length about why Lord Justice Bentley, for the reasons that are connected with the separation of powers, is not prepared to allow there to be consultation implied into this situation. And I'm not sure when you've last read the conditions here, but can I summarize it? What he's really saying is, if you're going to have consultation, then there are a lot of questions, administrative questions, that have to be asked. They're complicated ones. They're set out in 43, and they're set out in 44 as well. Now, I can obviously read them if you. I think perhaps 43 is where the real obstacle comes, and what I've tried to do to answer it. The real obstacle, he said, which I think stands in the appellant's way, is the difficulty of propounding a principle which reconciles fairness to an adversely affected class with the principles of public administration that are also part of the common law. These are not based on administrative convenience or potential embarrassment. They arise from the separation of powers and the entitlement of the executive government to formulate and reformulate policy. I suppose that's a phrase that's used in other authorities, albeit subject to such constraints as the law places upon the process and the product. One set of such constraints in modern public law are the doctrines of legitimate expectation, both procedural and substantive. Some have been touched on above. For example, the requirements of candour, open-mindedness, when either law or established practice calls for consultation. The duty to give reasons is another area in which there has been marked growth. So I pause again because in terms of the common law, I think there's agreement that the categories are not closed and that it's an area of development. Again, choosing the words of Lord Justice Laws in an earlier case. This last sentence is important because it is posing what I'm suggesting is thinkable. It's not unthinkable that the common law could recognize a general duty of consultation in relation to proposed measures which are going to adversely affect an identifiable interest group or sector of society. Now, I'm asking your lordships kindly to insert the word notice there, a general duty of notice, which does not entail, we say, any of the complications that are threaten or could threaten the separation of powers and so forth. He's saying that even on consultation, it's not unthinkable. And therefore, we say the door is open for consideration of a common law duty in certain circumstances. Now, what I've endeavoured to do overnight, I hope your lordships have it, was a draft of the property. I would ask your lordships to consider. May I just put this away for a moment? Do your lordships have, I sent it over separately on an email and asked that your lordships be provided individually with it. I hope that has happened. If not, may I just pause to make sure it has?
Was it called speaking note?
May I, if your lordships have it and your ladyship has it, may I read what I have drafted?
Is it the speaking note?
Yes, it's headed speaking note. I'm terribly sorry. That's not something I described it as. In fact, it's just a proposition that I felt would be better in written form rather than me spelling it out as a result of our skeleton.
I have it now.
I just pause to make sure.
Yes, yes, I think we've all received that.
Yes, I'm sorry it was classified as a speaking note. You must have opened it and thought that's a very short one.
We did.
I'm sorry I can't.
We asked if it was correct, and it contained everything it was intended to be contained, but now you've explained it now.
May I just, this is in answer to Lord Justice Sedley's posed question on paragraph 44, the real obstacle which I think stands in the appellant's way. They didn't draft anything which might indicate the parameters, because obviously if you're going to have a general duty arising from common law fairness, you need to be able to describe the parameters of what it is that about which you speak. So that is what I've tried to do here. So may I just read it? Where a primary or secondary legislative proposal substantially alters well-established individual rights or entitlements. So may I pause there, because this proposition fuses the various concepts. So that part of the proposition gives rise to the substantive legitimate expectation. In other words, between 1940 and 1995, women had a substantive expectation, quite reasonable, they'd be getting a pension at 60. That's the simple point. It's what Lord Justice Laws called ordinary expectation. So it's nothing exceptional, other than in this particular case, obviously, it's more complicated, and also it's talking about a period in the future. So slightly, it's an unusual and it's a rare situation. But that's the first half of the statement. May I go on from that? Because what happens is that thereby causes a serious adverse effect upon the basic welfare and well-being of an identifiable group. Well, we've made the basic welfare point already. The identifiable group is the women we've called the cohort of the 1950s. There's a serious adverse effect already described. Then we say that group, in relation to the deployment of the secondary procedural legitimate expectation described by Lord Justice Laws as arising from a substantive, it's, in other words, all in the area where there's no express notice. And their common law fairness, as it were, is triggered, that there should be the individualized notice of the change. So all three principles and concepts are fused at this point, substantive, procedural, and common law, to produce a situation we say is satisfied by this case. And we say that Lord Justice Sedley has in fact left the door open to this particular aspect of the matter, because in the later paragraphs, if you kindly go return to his judgment in the second volume at tab 28, same paragraphs, a little bit further on, tab 28, volume 2,
Yes.
and it's paragraph 44. What are its implications? The appellants have not.
Would you like us to, Mr. Mansell? Would you like us to read this passage?
And then the questions that arise in that paragraph, that if the duty to consult were to be imported through the duty of fairness, then it would. Who's going to be entitled to be consulted? These are questions that don't arise in relation to notice. So I don't go through them. 45, the proposed duty is not unthinkable. So he repeats the same point. which I certainly pray on behalf of the applicant, appellant in this case. And then over the page.
Yes, but your problem, Mr. Mansfield, your problem is he goes on to say, indeed many people might consider it very desirable, but thinking about it makes it rapidly plain that if it is to be introduced, it should be by Parliament, not by the courts. Yes. That's what he says.
That's what he says, but it's in the context of consultation.
Yes, but isn't the important difference this? It's not just that notification is a lesser burden than consultation. It's actually a quite different animal. Consultation is to give you the chance to influence the law, the making of the law before it's made.
Yes.
The injustice you say has been suffered here is that a law has been made which will affect lots of people in circumstances where you say it is fair that they must be told what the effect of the law is. And with respect, therefore, I don't think you're right to talk in your speaking note about a legislative proposal. We're not dealing with a legislative proposal here. We're dealing with a law. And your real point is, once you've made the law, there will be circumstances in which you ought to tell people individually who are going to be affected by it what its effect is. And the problem about that is that once you've got a law that's actually been made, it's for Parliament to decide what notice provision or notification provisions there should be about the changes which it has introduced. It would have been perfectly possible for Parliament to say, in the 1995 Act, section 167, I invent, every person affected by this must be given at least X years notification of how this change will impact on them. But Parliament didn't choose to do that. And is it right for the courts to introduce such an obligation by way of a gloss or on something that Parliament didn't choose to do?
Well, may I address that? Because I've used the word proposal because, of course, it's a proposal before it passes into law, and obviously after that it's still, in a sense, this is may I say, a rare situation in which the legislation in 95 and the later one are talking about a regime that will come into being 15 years later. So the situation in which we say notice may arise is obviously at the stage that the proposal is being discussed in bill terms. Then you would want to discuss whether it's going to be necessary to put it in the bill. But if it's at the stage this is being discussed in 1995, I hope it's fair to say maybe at that stage nobody actually recognised it being 15 years ago, that it would be necessary to put that proposal in the bill. That it's possible, and we say here it's an oversight. They certainly should have put it in, and the fact that it's not there, adopting Lord Justice Sedley, doesn't mean to say the common law shouldn't step in to rectify the situation once the bill becomes an act and the act has royal assent, and then it's there on the statute books. Nobody really woke up to it, because it wasn't until the surveys after the turn of 2000 and into the 2000s themselves that people began to realise that the message hadn't got out. And that's the injustice, we say, of this situation, which the common law, in all fairness, when people were reasonably expecting 60, could and should step in to say, well, we think, we the courts, we the common law think, that this is a situation which can only be rectified by ensuring, and certainly for the future purposes, when people are thinking about schemes that aren't going to come into force for 15 years, that people are supposed to keep it in the forefront of their minds that it's going to happen, and it's going to affect them. Then we say, this is why it's so important. One doesn't want to take over the legislative function. The whole point about the common law fairness is that it's, as it were, plugging gaps that occur in the democratic process. And I've only used this particular judgment because it's the nearest to the question of the principle of notice that we can get. And the next case, DLT, has some statements of law as well. But can I just finish this judgment in paragraph 47? It's on the next page, 46 and 47. I don't deal with the question of specificity because that again deals with consultation, and I've tried to draft the proposition with specificity in mind. However, 47, for all these reasons, I'm not prepared to hold that there was at common law an obligation to consult. Well, again, I make the point different. Those affected or their representatives before introducing material changes to the immigration laws. This is the passage I do rely on. I do not seek to elevate this to a general rule that fairness can never require consultation as a condition of the exercise of statutory function. Extremely important, we say, that it's not a rule of law that you can't do it. The question is whether in the circumstances of this case, which are unusual and exceptional, which I've tried to translate into the proposition, where that something like this is being changed dramatically, then we say there is an obligation that arises through the common law and through the secondary legitimate expectation. The secondary legitimate expectation, as your Lordship rightly pointed out, in fact is really more to do with, and it was described like this, as the right to be heard, whether it be on immigration rules or something else. And I'm not employing the right to be heard. It's much more that the common law has a duty of fairness in these circumstances. So the other case that has a bearing on this, but it's just in question, it's in the case that makes the distinction by Lord Justice Laws is Niazzi, which is in the same volume 2, 2008. Well, it's the following year, interestingly enough, and it's tab 31. If you have tab 31, so all of that discussion in the last case, in Napier, was in the absence of it. What the judgment in the lower court indicates, and we say we never argue that there was any express promise. But this topic is addressed again at paragraph 33 in Niazzi, which is a series of cases relating to schemes concerned with compensation for miscarriages of justice and fee levels for those representing them on their compensation claims. Paragraph 33, the beginning of it is rather faint, but can I come in at the bolder print halfway through that paragraph? Presumably there will either be an authoritative representation of what the relevant policy is and will continue to be, or else simply the fact of a policy's being settled and established in practice. Well, pausing there, we say here, on that basis, there is a policy in relation to, and a practice, of the pensions. So that's the substantive element. A promise or practice, but not the kind of promise or practice found in the paradigm case, which I've already mentioned anyway earlier, of proceedings of procedural legitimate expectation. In the procedural case, we find a promise or practice of notice or, interestingly, that's one of the few occasions that notice has been, as it were, uncoupled slightly, or consultation in the event of contemplated change.
Can I just pause there, Mr. Mansfield? All of this is about a completely different area. It's about a contemplated change. So even the reference to notice isn't on all fours with our case. Our case is a different one. Our case is where a change has occurred by Act of Parliament. There's nothing left to do about preventing the change happening. It's simply about notice of its effect. So does any of this help you?
Well, in my submission, yes, it does, because it indicates that there are boundaries here, and there is a concluding paragraph. Can I just go to the concluding paragraph, which I submit does help, on the rationale of the situation. And of course, it is a different case because it's happened after the legislation has come into effect. But one is still entitled to say what should have happened with this legislation is noticed. And if it's right that there should have been notice, then we're entitled to argue that it's unlawful in that respect, and a declaration to that effect. Now just read postscript paragraph 50. And it's dealing with the fact that the judgment in the lower court was ruling on the basis that there was no express matter of authorization or no established practice, but we weren't arguing that. So we're saying what hadn't been considered adequately by the lower court is this further dimension that when, in the absence of all that, that is, express authorization or practice, what happens? Nothing? You let it go? Or you just say, well, it should have been in the Act, but it wasn't. That's where the common law, we say, steps in. In this paragraph, we say, helps. So if I'm a very broad summary of the place of legitimate expectations in public law might be expressed as follows. The power of public authorities to change policy is constrained by the legal duty to be fair and other constraints which the law imposes. A change of policy which would otherwise be legally unexceptionable may be held unfair by reason of prior action or inaction by the authority. If it has distinctly promised, well, that's the other case, but I'll read it because it's all part of the paragraph. If it has distinctly promised to consult those affected or potentially affected, then ordinarily it must consult the paradigm case of procedural expectation. We don't need that. If it has distinctly promised to preserve the existing policy for a specific person or group, well, that's the pension policy, who would be substantially affected by the change, which they are, then ordinarily it must keep its promised substantive expectation. If without any promise it has established a policy distinctly and substantially affecting specific person or group who in the circumstances was in reason entitled to rely on its contingency and did so, then ordinarily it must consult, well, insert notice please, before effecting any change, the secondary case of procedural expectation. So what I'm doing, I hope fairly, is importing the rationale here, the underlying jurisprudence into the issue of notice rather than consultation, because it doesn't have all the trappings and complications of those other instances. So we say here that the combination of Baffio and this case indicate very clearly in our submission that even when there is no express, as it were, provision, common law can step in and ensure that fairness proceeds. And if there's been unfairness, if your lordships were to declare there's been unfairness in relation to this, well, then obviously it's a matter for the government to decide how they're going to rectify the unfairness, the Act having been passed in '95. They're very apt, it would seem, when they need to pass another statute, they do, on all sorts of fronts, and certainly on this one. They've certainly passed a number of statutes at different times, reconfiguring how the pension scheme will work, and since all of this as well. So we say, if the common law is imported here, it would be extremely important in order to rectify a situation which is, we say, a very common complaint in relation to this area. May I just pause for a moment, because I've been, apparently it's the last bundle of statements, JDB 376. I I can't put my hand on it at this very moment, but I will ensure that you are given the references to the statements of the two claimants who indicate how they would have done things differently had they known in advance.
Thank
So
you.
can I, particular matter for the moment? Was I going to pause for breath, if nothing else, for a moment? That's as much as I would want to say in relation to the question of notice, unless there's any other matter that your lordships would want me to consider.
Thank you.
And may I pass to the final ground? And this is delay, ground 4. May I say this was not a ground that was developed before the lower court. It was there as a ground, but it was not developed in argument to any extent. And certainly I don't recall that being done. However, we are much obliged to the court for providing a very recent authority, which your lordships will be very familiar with. But I would like to start with that authority because there is, it's called Badgemus, and it's been inserted into the end, I think it's tab, yes, it's tab 61, and it's in the 4th volume. Tab 61 in the 4th volume, and it was heard this year, or his judgment was this year, and it was heard this year as well. Yeah. And just as a precursor to just looking at the question of delay as it's dealt with in this authority, the question of delay is addressed at paragraph 38 onwards. The other points we would make as precursors to this is that, in fact, if we are right about the regime that has been set out statutorily from 1995 right through to the present, that we say that this is a continuing prejudice, that is, and a continuing act, if you like, that is affecting this particular group. So there's a continuing matter. That's the case of O'Connor, and also as a precursor, which is the Equal Opportunities Commission challenge of legislation that it's not uncommon for the courts to consider a statute that may have been passed some time before. However, this particular authority is pertinent because it's talking about not only the absolute bar, and I know my learned friend is not concentrating on the absolute bar, but the question of undue delay, and obviously the point that we want to make, in a sense, apply to both situations. So that dealing with delay in this one, that is badness, and dealing with the statute and also the review to which it relates is early on. But it would appear in the later paragraphs that follow that one that the distinction comes between and is drawn at the discussion section, which is at paragraph 59 onwards. Finally, because dealing with the rules, if I just read paragraph 59 in the beginning of it, under the heading timeliness, paragraph 59. So far as relevant to the present claims, CPR 54.51 provides that a claim for judicial review must be made promptly and, in any event, not later than 3 months after the grounds to make the claim first arose. And then the Senior Courts Act deals with the undue delay point, which I know the friend is relying upon, where permission may be refused. Now, if you'd be kind enough to turn over the page, the later paragraphs starting at 60, 61 and 62 make an important categorization or taxonomy, as it's sometimes referred to, a classification and definition between two types of case, which this particular case, Badmus, was endeavouring to distinguish for the purposes of when does time run in a claim. The distinction, and again, because your lordships are so familiar, I really don't want to, as it were, go over ground that you know probably almost in your sleep, so I'm not going to do it other than indicate there are two categories: person-specific and abstract. Easily illustrated, not always easily put into practice, but abstract, as I think your lordship points out in the judgment, is most readily described as those cases where, for example, a group that have a particular objective, which it comes within legislative objectives, are challenging the legislation as such, per se. Person-specific, we say, as the judgment does, it is much more dependent upon when the particular regime was applied, and there's discussion about that, which occurs in paragraph 69, 70 and 71 onwards. So that if I've distilled correctly that time runs from when it is applied, and that is actually spelled out in a later paragraph, when it is applied to the person affected. So it's paragraph 75, where there's a citation of Lord Justice Singh, and I would like to rely on that because it is employed in this judgment of Badmus. Now, in paragraph 75, the citation from Lord Justice Singh, I'll just read that. In theory, a very strict view might be taken that time begins to run from the date when secondary legislation is made, or at least when it comes into force. However, that would be contrary to both principle and authority. It's unnecessary to go into that in detail, since in the hearing before this court, Mr. Tam, representing the department, made it clear that the Secretary of State accepts that time for judicial review begins to run not from the date of the legislation, the 2005 rules in that case, secondary legislation, but from the date when that legislation was applied in a particular case. In other words, here, the relevant appeal decisions in 2014. So that's referring back to the case from which it's taken. And then it's fair to say Justice Singh didn't cite any authority for his view, or against it, for that matter. Paragraph 77, very important. We consider that none of the specific cases relied upon by the department's submission and inserting what it's the representation, that the appellants fall within the abstract category because, by contrast to those cases, the individual decision was made to apply a flat rate. This is to do with work rates and payment of people in detentions, a flat rate to them, but rather it was merely applied as part of an administrative process. So the question is, where does the administrative process begin, which he deals with, which you deal with? On the contrary, we consider, in support of Mr. Thurley, representing the applicants, appellants, or claimants in that case, alternative analysis, that the correct principle is that the grounds for making a judicial review claim first arise arise when the person is affected. And then in the language of paragraph 167 of the case, by the application of the challenge policy or practice. So that again is an important sentence in that paragraph. And the paragraph 78, in a sense, I don't read the rest of that one because it's specific to the case, but 78 rounds it off. It's the last sentence of 78, because therefore, on that basis, if that's the right principle, when was the applicant first affected by the particular practice of flat rate payment? And Your Lordship held that it was when he was detained in the IRC, the immigration centre, because from that point onwards, the low or the flat rate wage regime came into play for everyone who, not everyone who was there, but everyone who chose to work, which most of them did. So this is person specific. Now we say that the pension case that you're dealing with is a classic person abstract, because those tables, for nothing if no other, demonstrate beyond peradventure that individual members of the group are being treated, in one case by date of age and in the later case by a cut-off date. So it's a situation in which until they become, as it were, affected by the practice of applying it, in their cases it's 2 separate years, just before it came in. For example, the case of the second applicant, it would be, in fact, in 2018, what they would come into being, because that's when they're not getting what they would have got.
Then aren't they out of time on that basis as well? I'm not seeing where this is going. I can't remember when were these proceedings started.
Oh, there's a chronology for Your Lordship.
No, well, just remind me.
It started in 2018.
I see.
In fact, very close to that date. Do you have page 61 in the core bundle?
But for one of them, it was 2016, wasn't it?
Yes, correct. Now, I'm not saying for all of them, it's the same. But if you have the chronology, it's quite useful because it's got the relevant dates on it. I don't think there's any particular issue about this. Page 61. In other words, the date when they would have got the second applicant 60th birthday is the date Your Ladyship's just mentioned, which is 2016. And on this chronology is inserted what I've already mentioned in opening. She became aware of it the previous year, but I'm leaving that to one side. We say that the date on which this scheme, if you like, becomes applied to her is then and not before. It can't be before because, in fact, all sorts of things could happen between 95 and 2016, which would mean bringing a claim before her 60th birthday would have been odious, because somebody would say, well, wait a minute, it hasn't happened yet.
How does that fit in with your notification point? Because I thought you said that the notification has to be substantially in advance of the date when they unexpectedly don't get their pension. So when does the judicial review claim arising from the lack of notification arise?
But we say that notification and notice are just slightly different. I've already covered that. I understand Your Ladyship's point. We are saying that for the purposes of standing or lockup, which is the way it's put in Badman, is that you don't get standing to do this. In other words, to challenge the question of whether it's fair vis-a-vis notification or notice, you don't have standing until time starts to run and you have something to put before this court. Now that won't happen. We say that doesn't happen until the actual 60th birthday in both cases. Now, the other one is in 2018, and of course, that was 21st of May, and I think the question you asked was when proceedings began. You'll see it's just below that, on the 8th of June.
So on that basis, I can't remember which is which. One claimant's claim is in time, and one is about 2 years out of time, or
That's right.
18 months out of time.
That would be my proposition. Yeah, you're right. One is just out. Well, it's 18 months out, in fact.
Yes, that's what I'm saying.
And the other one's out, is within. But we would say this would be a case, if we're right on the interpretation of this authority, this would be a case where, although in the case which is out of time by 18 months, that it may be a case suitable for the exercise of discretion to extend time to cover her case. And that is the first applicant, not the second. So we say it's very important that this, in this dimension that has been decided in that case, Cadmus, it is taken in that way. And it then overcomes any problems of, well, does it arise 10 years before or 5 years before? No, because that relates to whether the common law duty is invoked, because in fact they haven't had sufficient notice. And it's a factor in the substantive hearing. The real question is, do we have standing? Because the lower court, sorry, I haven't directed you to it. I don't know whether you probably remember. It's dealt with very, very shortly in the judgment, this question of delay. And if we kindly turn back to the core bundle and the judgment, which is therein, and it's 8. Delay is dealt with in paragraph 99, page 99, paragraph 124. We do not intend to address the question of delay at any length, since we've considered and reached substantive conclusions on the arguments advanced. However, it must be recorded that the chief substantive changes to the SBA and so on. So in other words, they're using the Act itself, 1995, and the delay between the Act and the launching of the claim in 2018. And we say, no, it isn't as is said in the text. It's not when the Act was passed, it's when it takes effect. Otherwise you get lots of claims which would be spurious or premature, and it would take two too. So it's really we would submit a very sensible, practical, if you like, way of testing the need for a particular claim as to the way it goes into practice. So, well, I don't intend to address you further on that, because we say that is a very clear authority on our understanding, anyway, of the matter. Now, may I?
Could I just ask one?
I think I've given you the reference, and I haven't had a chance to go and actually look them up. But may I just repeat that?
You couldn't answer my question, could you?
Yes, I'm so sorry.
Sorry. Mrs. Justice Lang, when she gave permission, didn't deal with the time point, I think.
No, she did.
What did she say?
I don't know that a Lang judgment. It certainly was raised, and she indicated that she was not. She ruled in our favour on delay, and said that we were perfectly entitled to run with it. Now, let's see where the judgment is of. I thought it was in the core bundle, but it might not be there.
No, it's not there. I've looked for it. It's not there.
Well, that's another one. Can I say from memory, because I was obviously still handling the case, I'll put it down on the list of things to ensure that you have before you first thing in the morning. From my remembrance of the oral argument, it was addressed, because I actually addressed that then, indicating, I remember authorities in which thought Justice Sedley was dealing with the question if we look at whether people have sat on their hands and all the rest of it, and we were claiming that none of these applicants had sat on their hands and that it was a continuing offence. The continuation point was, I think, the one that carried the day at that point, because obviously badness hadn't been decided. Continuation was the basis on which it was regarded as, and she granted an extension of time on that basis. But I'll clarify that from the actual words of what she said, and I apologise that it's not in the bundle.
Was there anything further?
No, not at all, other than those documents which I'll make sure are available.
Well, if the other members of the court don't have any further questions, I just say thank you very much indeed, Mr. Mansfield.
Thank you.
All right, so now I think it's for Sir James to take over.
Can you see and hear? If I speak, does the picture come up?
Yes, a picture has come up. Mr. Mansfield, could you cancel your video, please?
Yes, I'm just doing that now.
Thank you, and also
Doesn't
the
always
and also the that's it. Well done, thank you, Sir James. Yes.
My lords, my lady, I was going to start with age discrimination, if I may.
Thank you.
It's a claim that's only maintained now in relation to the ECHR. The EU law claim based on age discrimination has been abandoned, so you can ignore in the judgment paragraphs 33 to 41. So far as engagement is concerned, we submit that there is no discrimination on the basis that a particular date is chosen for the introduction of the new pensions regime. There is no principle of equal treatment in time that is engaged. And the initial theory in the Strasbourg case law, as you, I'm sure, have seen, because you had a discussion about Minter and the other Strasbourg cases this morning, the initial theory or starting point is that if you've got a starting date or a cut-off date, with a new regime being brought in by legislation, all that does is to delineate the date of legal change. And differences between the groups who are before and after, and the legal positions of those before and after, is not discrimination.
But is that the case, Sir James, where the cut-off date is in fact an age?
My submission is that it is. I was taking the propositions slightly in order.
I'm so sorry, I'll shut up and let you get on.
No, it doesn't matter, with the lighter one first. And the lighter one is established by Minter and the third case that you were referred to earlier on this morning. So Minter was tab 18, that's probably the only one we need to go to. I think the tab before was Zamet, which was the leaseholder's case, but Minter was the prisoner's case. And the relevant paragraph for present purposes is paragraph 67 on page 354.
Sorry, can you
in bundle 1.
Bundle 1. Okay, thank you. Yes.
And you see the principle which is established in that paragraph, in particular in the second sentence beginning on about line 5. And then taking it forward by...
Sorry, so are we in Zamet or Minter?
We're in Minter, my lady, I'm so sorry. Tab 18.
Yeah.
Minter, page 354, at paragraph 67. So we're bundle 1, tab 18, para 67. It's really the second sentence to the end of the paragraph that sets the basic principle. see it applied in a specific context of pensions and age discrimination, which may come closer to the question that my Lord Justice Underhill posed to me earlier on. If you go back in the same bundle to tab 12, I should say, just by way of introduction to Ackerman, there is nothing that diminishes the force and effect of a judgment of the European Court of Human Rights simply because it is an admissibility decision. As you know, there are various grounds for concluding that a case is inadmissible, and one of those grounds is that it is manifestly ill-founded. In other words, the principles and their application in a particular context are so clear that it can be so categorised. That was this case, as one sees from page 194, in the paragraph effectively immediately above the declaring it inadmissible bit. So the complaint is declared manifestly ill-founded and for that reason inadmissible. So this is regarded as clear law in the European Court of Human Rights system. And you see the nature of the complaint. The relevant one, the relevant complaint for our purposes is on page 191 in the second full paragraph of the page. And it's a complaint about age discrimination, alleging they were likely to receive considerably lower pension when reaching retirement age than earlier generations did. Well, one can substitute for that their SPA was going to be higher, so they'd have to work for longer before they got access to the pension benefit. But it's essentially an age discrimination complaint with an allegation of disadvantage or prejudice, with the comparator groups being those who were, as it were, pre-change, compared with those who are post-change. And the way in which that is disposed of, it's a paragraph, you'll be very familiar with it now, but you see it in the second paragraph on page 192. And we effectively note that that paragraph is saying effectively that states need to be able to adapt to changing systems, particularly in the pension context, and alter the rules. And you can't get a discrimination case off the ground, whether directly or by redressing it as an age discrimination case, by comparing the positions of those prior to the change and those after. And to some extent, all pension claims are going to be referable to age, and age is going to be inherent within them. So we make three short submissions in relation to that Strasbourg case law. The first is that that logic we submit precisely applies here. The comparison in our case for the purpose of age discrimination is and has to be between women born in the 1950s and those born earlier to whom the legislation equalising the SPA and or raising it to 66 does not apply. And the key point is that the nature of that comparison relies upon the date of the legislative change, rather than unequal treatment on a single given date of persons to whom the legislative regime applies. The use of the date for commencement of the new regime, or in our case, the extrapolations of that to try and soften the blow, as it were, by creating a set of different dates on which the changes come into effect to soften the blow of the changes or provide an additional period of time to react, is the inevitable consequence of bringing the regime up to date. And so the position is, we respectfully submit, precisely and on the logic of Ackerman, as the Divisional Court described it in paragraph 52 of their judgment, page 81 of the core bundle. where they said that the groups weren't comparable precisely because they comprise people of different ages who are legitimately subject to different legislative regimes, and states are at liberty to alter the age at which state pension becomes payable, and a person cannot claim equal treatment in time. So we say that the logic of Ackerman applies precisely here. Secondly, we have here a change being made from a state pension age for women at 60 to a state pension age which was 65 and then 66. And you'll recall that it did have the softening in terms of making the cliff edge that would otherwise have been, if they'd simply said, well, today it's 60, tomorrow it's 65, they made the cliff edge in effect a shallower slope. It was referred to as the taper, I think, in the judgment below, delaying the introduction of that. But one can test this point, the Ackerman point, by asking, well, if they'd simply done it immediately on the day, with a feature of the changing regime that those before were still at 60 and those the day after at 65 or 66, then it would be entirely clear that it would be a function of simply bringing in the legislative change. It isn't discrimination, because the change in the state pension age is the very change. And that position can't be respectfully submit alter because you bring in a taper. They're just different, softer lines, and they're not a difference in kind or in nature. They're simply starting the thing at different dates for the purpose of creating softer lines. But with those 2 points in mind, just to pick up on some points that were made this morning in discussion, we do submit that we're not dealing here with a single regime that says, for example, well, 48-year-olds are treated one way, 51-year-olds are treated another, when you're considering the raising of the SPA. The comparability arises because one regime is succeeding another, and in a context in which age is inherent in the nature of the change, because you are dealing with state pension age, by definition. I think, my Lord, the Master of the Rolls, on a slightly different point, asked my learned friend whether her case was truly that there were in fact different factual circumstances that rendered the two groups comparable. My Lord will recall the thought and the discussion that followed the thought being put out there. My short and respectful submission in relation to that is that Ackerman, in the paragraph that you've seen, has nothing really to say about the general factual circumstances of later or earlier generations. It's not inviting or proceeding on the basis that you do a factual comparison in that way. Its point is that you simply can't in principle rely on being in the earlier or the later generation or a comparison between those two in a context such as pensions and changes to the pensions regime, which is why I started with the lesser Minter proposition and went to Ackerman in the specific pensions context. But it doesn't invite, as it were, a change of the position in Ackerman if only you can demonstrate that factually there are similarities between the groups. And then my Lady Justice Rose asked the question, I think, after a bit of attempting to clarify my learned friend's precise case with her. Is the case that was being made, I think was the question, that here you've got discrimination after the act is in force, I think was the way my lady put the question. And my answer and submission in relation to that is that the act makes the change, and the change is to equalise, so the comparison in relation to that is with women who were not equalised, in other words, those before the act cuts in. And that is about point in time, if I can put it in the Strasbourg shorthand, in the pension context, before and after what is perceived to be an unfavourable change.
Right, because even if you had the change on one day, even if you said, right, from tomorrow, everyone has a change, it gets their state pension only at 65, women who were already 63, say, would still get their pension. I mean, it would be contrary to all sorts of laws to
Make it retrospective.
retrospectively, then I think you really would be in business, to James, by saying, right, well, even if you're already in pension, you still have to wait till you're 65. So even in that situation, there would be a cohort of women aged 63 who were getting their pension and a cohort of women who were 63 who would not be getting their pension. But you say, well, they can't compare themselves with each other because the reason why they're in a different group is that one was affected by the legislation and one was not.
That's essentially what it comes to, and that is to be contrasted with a provision that says, here we've got a single piece of legislation and we're drawing lines within the legislation on a substantive basis on the grounds of age.
I mean, I think that the thing that causes me, if I may say so, on this point, some reason to be cautious, is that you want us to, as it were, endorse an absolute principle that where the age discrimination in a pension case arises simply from the selection of the date on which the change in the legislative provisions will come into effect, whether it be state pension age or otherwise, doesn't really matter. It can never be the case that a disadvantaged claimant can say that we are in a comparable position to the earlier, to the people who came before us. That's what it comes to. It's an absolute rule. And that's not actually what Ackerman says in that paragraph. The paragraph says the applicants have not established that their own situation is comparable to that of earlier pensioners. It goes no further than that. I mean, there are lots of other points on this particular Article 14 point, but I can tell you that I am cautious about drawing out of that paragraph and those words the kind of absolute principle that you'd like us to.
My Lord, I think my only response to that is to invite you to read that paragraph and that conclusion along with the facts which they were dealing with and which that paragraph disposed of. In other words, the actual nature of the complaint, which you see in the second full paragraph on page 191.
Well, that may be so. I mean, what you could say, that you aren't saying, what you could say is that there are a whole series of reasons why the government decided to introduce these changes, and they included factors, for example, such as the number of, the proportion of people who would be projected to be of working age, who would have to support the proportion of people who were retiring, and all sorts of factors, and that the claimants, in order to satisfy that qualifying sentence that I read out, would have to show comparability, would have to address each of the factors of which the government was relying upon, and to say, well, there's absolutely no difference between somebody who was born in 1942 and myself born in 1958. And that exercise has not been done, and obviously that was the exercise that was not done in Ackerman. But you're not saying that. You eschew that exercise, and you simply say, well, it's a complete statement of absolute principle. So I think that, to be, if I can be perfectly candid, is where, on this particular point, I am quite cautious.
Well, my Lord, I understand the caution entirely, because one's always cautious about an absolute principle, knowing full well that facts can make a difference, and I'm sure in Strasbourg particularly. But I think I am entitled to say that in the context of Ackerman itself, the nature of the complaint was simply that as a result of the changes, one group of people, those before the relevant change, would get more or less.
Could you help me, Sir James? I'm sorry, I haven't quite picked up from Ackerman. What were the changes? which had this effect. I agree the implication is that that must be the case, but you don't get that from the second full para on 191.
No, I think you have to go back to the very beginning in order to get
Yes,
the
I've
relevant
been
fact.
looking and I couldn't find it, but I don't know whether you can or can.
I was looking at the bottom of 186.
I'm just wondering how.
It's over the page, isn't it? Isn't it 187 the first full para?
But why? It's not clear why they currently profited from higher pensions. Does that mean that the rate of pension has been reduced as a result of some legislative measure? It's not identified what that is or when it occurred. I agree there must be some reason why the older generation are getting higher pensions than he would get. But I'm not clear.
I'd always rather understood it from the bottom of 186 running over that there were a succession of changes that were designed to deal with German reunification.
Ah, that's very interesting. Yeah, well, to the fact.
If you look at the bottom of 186 and over into 187, the paragraph before the one you've just been looking at. And I'm not sure precisely how the mechanics of it worked, but no doubt as part and parcel of that, a succession of changes were introduced which had the effect that after the changes to support German reunification, one lot were going to get less and one lot were going to get more. So the old generation was going to be better off, as it were.
I wonder, well, that's rather my assumption as well. The more I look at it, the less I see that is what it's about. It's quite difficult to see exactly what the nature of his complaint was. Was it that he wanted to have a private pension which would do better?
He certainly wanted to do that, but that was a discreet complaint, I think, in fairness.
Yes, well, yes, but I can't see what else he's not been allowed to do or had changed that produces the effect that we've all been talking about. I don't know how much, well, I think it does matter a bit because the reasoning is very thick, and as you rightly said, you've got to understand it in the light of the complaint they were addressing. But I find it quite difficult to see what complaint they were addressing. Maybe it's not sensible to do it now, but if you and your team were able to see if you can cast any light on it by reading every word overnight, I mean,
there's a specific explanation as to why precisely under the German system they were worse off. As I say,
I don't want lots of detail. I want to know what had happened to produce this effect.
Yeah.
Anyway, there we are. Thank you.
In any event, that's Ackerman. We'll see if we can find some more to assist you with in relation to the facts on Ackerman. I suspect the answer may be no, but we'll have a look overnight and see whether we can. We'll make the attempt at least. And the respectful submission, the third submission in relation to Ackerman, is that there is no inconsistency between the Ackerman position, leaving aside the fact that Ackerman doesn't appear to have been cited in either MacLeod or in Hughes. There's no inconsistency between the two. MacLeod was about the application of different transitional protections to judges of different ages at a single point in time, with the oldest, who it turned out needed the protection least, being most favourably treated, and the youngest, who needed the protection most, being less favourably treated. I'm sure I won't need to tell my lords and my ladies precisely how that disadvantage worked. Anyway, mercifully the thing has been put right. But the point for present purposes is that they're using it, we're not in that comparator. We're simply not comparing anything equivalent to what were the comparison that was being done in Ackerman and the comparison that for the purpose of the age discrimination claim is being done here. And the same in relation to Hughes. Hughes, like MacLeod, is a case where the substantive rules distinguish between older and younger members of a pension scheme with greater protection given to the older ones. But it's not a case that either is about or could be presented as being about the timing of the introduction of a legislative change with the nature of the legislative change inevitably involving age, because there's an inherency in the nature of the change being made. So they're non-comparable is the short submission for present purposes in relation to Ackerman. And Lord, just to pick up on, finally, in relation to engagement, just to pick up on the point that I was halfway through dealing with my Lord the Master of the Rolls about what we're not saying. My Lord, you're right to say, we're not saying, look at these comparisons on the facts, there are differences, this is why Parliament has done it, there's a whole bunch of separate reasons. But you will appreciate that all of the sorts of issues that you were placing within that question were the subject of consideration on the heading of justification.
Of course, yes.
Why all this was done and how it was done. But my Lord is right, we do seek to extract from Ackerman something rather harder edged than that. Just so that I don't lose sight of the fact that some of those issues flow from justification. If you wanted to look at comparability on a broader basis, there is more than enough in the reasoning on justification to indicate that they are non-comparable, even if one spread the factual net a little wider. But I hope I fairly acknowledge that we're seeking something sharper than that.
Yes.
Justification, then, if I could turn to that for the remaining 10 or so minutes. And I start with the approach, in principle, in relation to justification.
Well, you skipped over one thing. I'm not asking you to spend time if you don't want to. There was what seemed to me a slightly odd situation, but I may have misunderstood Miss Hill on it, where she accepted that the comparator that the claimants were relying upon was what we call the A group. In other words, what I've described as the pre-1950, April 1950 group. But her discrimination was all seemed to be by reference to younger women. It wasn't by reference to that group at all. And you remember there was a series of exchanges where we sought to sort of tease that out. And she was saying, well, the trouble is that this group, in the 1950s group, earned less, have less, they need to have their pensions earlier, they've got responsibilities and so on. And that seemed, certainly to me at the time, to be a somewhat illogical position to take, because that wasn't the comparator group. But you don't want to address that point.
Well, Marlon, I was going to do it a little bit later, but I can do it now. It's probably a link point, so let's do it now. I wasn't going to major on it because it seemed to me that the court had the point. But whatever else you do, you've got to identify, for the purpose of age discrimination, what your comparator group is for the purpose of making good a difference, a relevant difference.
Yes.
And she acknowledges, as you rightly point out, that for that purpose, her age discrimination claim can only really work if it's a comparison of the category A and beyond groups with those affected by the legislation. And the difficulty that then arises is that you then have all of the other comparisons in relation to a slightly different group. Well, in principle, the submission is a simple one, which is that once you've identified your discriminated group for the purpose of the difference of treatment analysis, that's what has to be justified. You can't jump between them. And that, I suspect, is why, and it's been quite a common feature of this case, if I may respectfully say so, both to her and to counsel who presented this argument below, it's been quite a common feature of the case that as it were, the case has moved as a matter of forensic convenience between the true group for one purpose to a different group when you come to a slightly different stage of the analysis, namely justification, where the comparator group is slightly different. And her only real answer to that was to keep repeating that this was a claim about double discrimination. You know what I mean by that? In other words, age and sex. But that doesn't justify moving between the two groups in that way. You analyse the age discrimination with the justification for that difference of treatment. You analyse the sex discrimination with the justification for that difference of treatment. Of course, it is possible to have both going alongside each other, because sometimes there are two operative discriminations in play. What you can't do is to alter the analysis so that you jump from one group to the other. So we respectfully agree that there's a logical incoherence there. But that's all I think I need to say about it.
Well, exactly. I think that's exactly the point. That when it comes to justification, you have to have identified what the discrimination is, and that's discrimination with the comparative group. And therefore, I mean, you've just explained it, and that was my reason for raising the point. You know, if your justification is aimed at a different group, or rather your attack on justification is aimed at a different group, we're not going to get very far.
Doesn't help me. I respectfully agree. And I suspect, in fairness to my lady from Miss Hill, I mean, she was alive to the difficulty, which is why it kept being lumped together. Well, we can have the discrimination points together, but the difficulty with that argument, as an answer to the logical concern, is that it doesn't work coherently in point of principle. Yes. That's how we put it.
Yes.
My Lord, so far as justification is concerned, I was going to go into a rather more banal territory, just to start off with, which is to make the point that manifesting without reasonable foundation is indeed the test. I don't imagine that any member of this court is going to benefit from me going through my usual mantra in relation to that. You know the point already. The debates have been raging in the Supreme Court for a number of years, and they were finally put to bed, we respectfully submit, domestically, query, whether, if so, how the debate has been reopened in relation to other contexts such as sex discrimination, which I will come to, by the JD case. But for present purposes, domestically, the debates were put to bed by the DA case, which is in tab 45. I don't invite you to take it up because I know you'll be familiar with it. Bundle 3, tab 45, and the relevant paragraphs, if you wanted to remind yourselves of them, are paragraphs 55 to 65 and 110 to 118. So it's manifestly without reasonable foundation. It's also to be applied as a single compendious test, if I can put it that way. And again, I don't invite you to turn this up, but that's DA analysed in Langford in the Court of Appeal, bundle 3 again, tab 46, paragraphs 50 to 56. And here, of course, you have, in relation to precisely the sorts of issues that my Lord was putting to me in relation to the discrimination argument a minute ago, you have all the features which indicate the broadest possible margin or respect. All of the features are pretty much present. You're dealing with primary legislation, considered, consulted on, debated in Parliament at each stage. You're dealing with massive fiscal consequences and context, the paradigm macro, social and economic context, if you will. I add social in because you'll be well aware that there are intergenerational fairness issues given the way in which the pension system is funded, namely by current taxpayers. I'll come back to that. It involves balances being struck between different groups and considerations of a social and political kind, and there are no right or wrong answers. And in those circumstances, the twin pillars on the basis of which the margin is broader or narrower all tend in favour of broader, the twin pillars being democratic accountability and who is better placed to make those sorts of judgments, the courts or Parliament. And again, you'll be very, very familiar with the case law. MA, the Carmichael case, which preceded DA and the Supreme Court. That one is, again, if you wanted reminding, Bundle 2, tab 36, and the relevant paragraph in the judgment of Lord Toulson is paragraph 32. I'm going down in court level just to give you three collected references. Top one first, Court of Appeal next, Lord Justice Underhill in Turley, tab 40 in Bundle 3, at paragraphs 20 to 25. And perhaps interesting and good in this context, if I'm allowed to so characterise it, Lord Justice Laws in Carson, at an earlier stage of the Carson litigation, tab 49 in Bundle 3, at paragraph 73, which is a pretty crisp exposition of why the margin is broad in our specific pensions context.
Are you content with the account of Lord Justice Higginbottom in the Joint Council for Welfare of Immigrants case?
My Lord, I am, and I'm going to come back to that. I'm going to come back to it in the context of sex discrimination. And I'm going to come back to it there because if there is particular wisdom to be gleaned, it's perhaps in relation to how you balance manifestly without reasonable foundation premised on all the considerations that I've just identified, on the one hand, against what is sometimes called a suspect category on the other. In other words, sex or race, as it was in that case, race discrimination, both suspect categories. Age, of course, which is why I'm not going there quite yet, age, of course, is not that. But in terms of the general approach to principle, the summaries of DA, how manifestly without reasonable foundation works, what its bases are, it's a pretty good collation, if I may respectfully say so, of the relevant case when it's bang up to date.
And he was certainly of the view that we are bound by a Supreme Court decision rather than JD as a matter of precedent.
None what he was, and that's going to be one of the key answers. Whether or not JD is right, which is a subject of some very considerable contention, it doesn't really matter at this level at least. Well, I was going to give you one other reference, and that perhaps might do for the day, if that would be convenient, and that's to the House of Lords in Carson, tab 27 in Bundle 2, and I don't invite you to go there for many paragraphs, but it's a helpful exposition of how pensions are funded, pay as you go and all of that. So there's quite a good bit of background in there from about paragraphs 21 onwards, with particular chimes perhaps into our present context between paragraphs 25 and 27.
Yes.
So with that, I'm going to turn first thing tomorrow, if I may, to the question whether the Divisional Court, who are thoroughly alive to all of this case law, about which there wasn't, in fairness, an enormous amount of dispute below, and manifestly without reasonable foundation being the relevant test, whether they applied the wrong test by asking the wrong question in some way, shape or form. A very brief section on that, and then I'm going to make some brief points on justification on the facts before turning to sex discrimination.
Very good. We did lose a bit of time from the timetable today, but do I take it that you're confident we will finish tomorrow in good time?
I'm very confident of that indeed.
Thank you very much. Well, then we will resume again tomorrow at 10:30. Thank you all very much.
Thank you.